Chief Justice, Your Honors, thank you for the opportunity to argue before this court. My name is Tim McCormack, and I'm here as amicus counsel on behalf of, we're arguing against the appellant in this case. Your Honors have asked some really good questions. I think it goes to the heart of this matter, what is a true threat? And the Supreme Court in Virginia Black teaches us that cross-burning for the intent of creating fear and harm in another individual is not protected under the First Amendment. We know that to be true, and that's what they have told us. In this case, we're talking about the lower court, Judge Jordan, making a finding after an extensive evidentiary hearing that Linda Ellis was put in reasonable fear of her safety.
Why wouldn't the proper relief be the alternative grounds that the trial court relied on, which was the protective order under 1913-4?
Your Honor, perhaps you could help me with 1913-4.
Protective orders and consent agreements, the court may issue upon filing of a verified petition, bring about cessation of acts of family violence, things along those lines. Just the court can issue a protective order to protect Miss Ellis in this case. Sure.
Not having been admitted to practice Georgia state law, I would defer to Your Honors on that. But I would say that when it comes to the protective order in this case, especially as it relates to the so-called First Amendment defense, you know, it needs to be reasonable in terms of time, place, and manner. You've got to look at the overall scope of the protective order. There's been some talk about, everything is down. Well, part of what this self-proclaimed internet domination strategist does is he creates forums. He creates discussion.
Hold on just a second. You're saying we judge an injunction prohibiting speech under the time, place, and manner test? Isn't it a classic prior restraint? So if it's speech at all, if it's actually protected speech, you can't touch it going forward. If it's not protected speech, you can do whatever you want to it. But I don't understand how time, place, and manner has any impact here.
Your Honor, thank you for the question. So it is our position that the First Amendment doesn't apply, and if it does apply, there's an exception to it, true threats. And even if it does apply, we believe it's subject to intermediate scrutiny, not strict scrutiny. And this is because the organic statute in this case, the organic Georgia anti-stalking statute, is content neutral.
Counsel, can you cite any case from any American appellate court that upholds an injunction that forbids a speaker from engaging in public speech about a subject, as opposed to speech to an unwilling listener?
I believe this case is, in that sense, a case of first impression. You know, this is an anti-stalking case. You know, at some level, we're turning the First Amendment on its head by saying that the lower court, that the state of the sovereign state of Georgia, under its reserve powers, health, safety, and welfare of its citizens, cannot pass a statute that can be applied by a local judge to protect one of your citizens.
By banning protected speech.
I missed that, Your Honor, please.
By banning protected speech, the police power extends to a prior restraint on protected speech.
Well, Your Honor, in this case, the court had the evidence and did find that the mode of attack was this internet website, and the judge said basically, leave her alone.
And even if there were true threats, can the judge do anything other than prohibit Mr. Chan from issuing true threats? Can the judge ban all the speech by Mr. Chan about Miss Ellis?
I can imagine cases that would come down on both sides of that. In this particular case, I think the lower court judge was well within his discretion to fashion a remedy. When Mr. Chan came into court, having already violated the temporary restraining order, and when the judge told Mr. Chan that he was going to issue an order, Chan, incredulous on the record, was in disbelief and was already trying to figure out how to get around it.
So your theory is basically one of he forfeited his right to free speech?
That we have briefed that when he crossed the line, Your Honor, when he put Linda Ellis in reasonable fear for safety, when he did his virtual cross burning against her, we believe that in terms of his actions against Linda Ellis, if Judge Jordan wanted to draw a bright line and said, leave her alone, I don't need to see you again, we think that's entirely appropriate.
So just to be clear, in your typical stalking case, where you have two partners and one of them has been horrible to the other one and threatened them, the judge can say not only stay away from the other person, do not communicate or contact the other person, but also you may not talk about the other person. You may not write anything about the other person. You may not tell your friends. You may not communicate to anyone who might then communicate with that person. You think that would be okay?
If the person that was ordered against had a propensity to disrespect the court, to not follow orders, and needed a bright line, I think there are factual situations where that could be proper. But I don't think that's what happened in this case, Your Honor. I think Matthew Chan is free to take his megaphone up to the mountain and yell at the top of his lungs that he hates Linda Ellis.
But he's not free to post on any website that he thinks her copyright views are horrible.
In this case, Matthew Chan, by the lower court's direction, cannot and should not do that because he put her in reasonable fear of her safety. Fundamentally, what the internet represents is it represents an ability to magnify stalking situations. It's not that you have to go to a website and click through 10 things, and it's not that the website is just sort of sitting out there static and has to be visited. That's not how it works at all. What we're talking about is the equivalent, if you can imagine, of a bully going into high school and taking a can of spray paint and writing FAGGOT across the locker. Everybody at the school sees it. It's pretty bad. But what we're talking about is even more pernicious. We're talking about literally a self-proclaimed internet strategist, domination strategist, tattooing the word FAGGOT across the person's Google name so that now 7 billion people on the planet can access it just by typing that name. We're talking about a situation where a 12-year-old girl...
If that happened, do you think, based on writing a bad name about someone, or even worse words you can come up with, you think just doing that is enough to get a protective order? Not to criticize the person and not putting aside the school context and what you can do to people in schools, but you think if somebody writes a name like that and exposes some of the public ridicule, you can get a protective order? Ban them from ever communicating about that person in a public way?
God willing, I hope so. Because there are cases, Your Honor, where 12-year-old girls have left their current school when they go home and they're not able to escape the bullies because it's on the smartphone. When they go home and to the new school and it follows them with them. And that's where this internet thing magnifies the impact of what we're talking about. Now, in a particular case, if a bully, thank you, Your Honor, honors.